Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, with our ongoing series on organization behavior. Today we are going to talk on one of the most interesting topics. Sexual harassment is often talked about and always complained about. So we are going to discuss in detail how we can prevent sexual harassment at the workplace. And to answer this question, we have once again with us in our studios Dr. Namita Rajput. Dr. Namita Rajput is principal in Sri Aurobindo Evening College, University of Delhi. Dr. Rajput has immense knowledge. She has contributed a lot in the field of academics. Lots of books are to her credit. She has written a number of articles which have been published in various journals at both national and international level. So let's welcome our guest, Dr. Namita Rajput, and let's try to grab maximum knowledge through her experience. Hello ma'am, welcome to today's lecture.
Good morning friends. Today we have a very interesting topic and very pertinent and important topic called Prevention of Sexual Harassment at Workplace. Now when you come on this topic of sexual harassment, this is not a female issue. This is not a joke. This is not something about to be ignored. It is a cause of paranoia and fear. It is actually a legal requirement to prevent, prohibit and address this issue at the workplace. Because this matter is something very, very important. If not controlled, this can be so disastrous and the organization overall can be down the drain. The reputation of the organization will be at bay. So the things are so important to be controlled at this level. So I'll start my lecture with a case of Indian Dalit women called Bhanwari Devi. Now she is a winner of a Neeraj Bhanot Memorial Award of her extraordinary courage, conviction and commitment. So let me give you a very brief story about her and let me connect this with the organization behavior and how she did the courage to take care of the sexual harassment at the workplace. Now Bhanwari Devi continues to be an outraged by her village. She lives in the outskirts of the village Bhateri, just 55 kilometers from the Jaipur, with her husband who has supported her fight throughout. She knows and she runs a self-help group with other women from her community and works with an NGO to support her family. Now this is a very important and a pertinent case. You can see the details on the internet so that you come to know about her courage, conviction and overall her extraordinary effort to get this Neeraj Bhanot Memorial Award. So in this backdrop, let me come on to the legal aspects of the sexual harassment at workplace. We have very important guidelines called Vishakha Guidelines. They are issued by the Supreme Court of India under the judgment of 1997, Vishakha and Oras versus State of Rajasthan. Now this is a very outstanding guidelines and very important guidelines for that matter which everyone has to embed in their policies to convert the courage of the women and to take care of the sexual harassment issues at the workplace. Now in the absence of the enacted law to provide for the effective enforcement in this regard, and to take care of the basic human right of gender equality and the guarantee against the sexual harassment and abuse, they laid down the guidelines and the norms specified herein after for a due observance of all workplaces and other institutions until a legislation is enacted for this purpose. And it is further emphasized that this would be treated as a law declared by the court under the Article 141 of the Constitution. The judgment of August 1997 provided the basic definitions of sexual harassment at workplace and provided the guidelines to deal with it. It is seen as a significant legal victory for the women groups in India. It is established that sexual harassment violates a women's right in the workplace and is thus not justified of a personal injury. So overall, it has been declared that if the organization have their own guidelines, if they do not have their own guidelines, they have to follow the guidelines which have been issued by the Supreme Court in 1997, which lays the guideline about the sexual harassment at workplace and also the guidelines to counter these kind of an issue. Now coming on to a Delhi rape case, it happened in about 2012. The central government appointed a judicial committee headed by J.S. Varna, a former judge of Supreme Court, to suggest the amendments of the criminal law to sternly deal with the sexual assault cases. The cabinet ministers on 1st of February 2013 approved for bringing an ordinance for giving effect to the changes in the law as suggested by the Varna Committee report. The Criminal Law Amend Ordinance 2013 was passed. Now, what is the advent of law? So, let me have a deep insight, give you a deep insight about it. By adopting the Vishakha Guidelines and the recommendations of the Justice Verma Committee, the Parliament enacted a sexual harassment of women at workplace. That is, it takes care of the prevention, prohibition and redressal. The Act was passed in 2013 and it is read as the Sexual Harassment of Women at Workplace Prevention, Prohibition, Redressal Rules 2013. Now, the effective date is December 2013. This statute supersedes the Vishakha Guidelines for Prevention of Sexual Harassment introduced by the Supreme Court of India. The statute extends to the whole of India and it is only for the protection of women at workplace. Now, I'll give you the basics about and the preamble of the Act, and it is very important to understand these issues so that if somebody is a victim of it, the things can be taken care of. Now, the section 1 of this Act deals with the basics. Now, an act to provide the protection against the sexual harassment of the women at workplace and for the prevention and redressal of the complaints of sexual harassment and for the matters connected therewith or the incidental thereto. So, this Act, the preamble revolves around the issues related to sexual harassment and obviously the concepts related to it and the basic redressals which are available to take care and counter the sexual harassment at the workplace. Now, no women shall be subjected to sexual harassment at any workplace. This is given under section 3, subsection 1. It's not that we are women and we should accept this kind of a act. So, this is overall the preamble and the main central issue of the Act, that no women shall be subject to any kind of a sexual harassment act at any workplace, which is specifically given under section 3, subsection 1. Now, understanding the basics of this Act, what is sexual harassment, what is a workplace and what is the aggrieved woman. Now, it is very important to understand these basic concepts, only then you will be able to understand and realize the importance of this Act and how to implement this Act and how to give the redressal of the aggrieved woman in this case. So, let me give you a brief introduction about who aggrieved women is. Now, all women working or visiting any workplace, whether a regular employee or a temporary employee or on an ad hoc basis or on a daily wages. It is enacted directly or indirectly by a contractor, working for remuneration, voluntary or otherwise. The terms of employment may be express or implied. It could be a co-worker, contract worker, probator, trainee, apprentice or a visitor. It also covers the women working in dwelling places or the house. So, we have seen here that this definition of aggrieved woman is very, very comprehensive and it not includes only the women who are on a regular payrolls, but also includes the women who are the daily wagers on the ad hoc basis, temporary basis. So, if the woman is of any of these category, she is having this kind of a right that she can counter any kind of an act which is under the Sexual Harassment Act and can get a redressal under this particular act. Now, this particular act also covers the women of the dwelling areas or a house, etc. Now, what is a workplace? It is very important to understand the basics of this act so that we are able to effectively implement and take the advantage, the basic and the good advantage of implementation of this act, and women can get a good redressal if she is subject to all these kind of act at the workplace. Now, what is a workplace? Any place visited by the employee arising out of or during the course of employment, including transportation provided by the employer. It also covers the organized and unorganized sectors, the government organizations, the private sector organizations, the hospitals, the nursing homes, the sport institutes, the facilities, the dwelling or the house. So, it is not a limited definition, it is a very, very extensive and having a good coverage, and all the possible places where the women go and work is called as a workplace, irrespective of whether it is a house or it is a nursing home, or is it a hospital or the educational institute, the private companies, the public companies, whether it is an organized sector or an unorganized sector, because this particular act of sexual harassment can take place anywhere, anytime, with any woman. So this act has to be comprehensive, and the Supreme Court efforts are very, very good in this regard, that they have covered all the possible extensive services which the women give in any of the sector, be it organized or be it unorganized sector. Now, taking my definition forward of the workplace, it is even extended to office parties, the offsuits, the outbound trainings, the client meetings, the training sessions, the travel for the office purpose, and any place one visits in the course of due to employment. So when you are working in an organization, it is not that you are always confined to your office. You might have to go out, you might attend the parties, you have to be going for certain outbound trainings also. It could be a travel which has been provided by your employer. So in any case, in any ways, if you are going for any reasons for the official purpose, that will be called as a workplace, because it is the matter and the incidents will not see the time and the place. So that is why the coverage is very, very extensive, and all the possible efforts have been made to put into the consideration of the definition of the workplace. So it could be travel for any kind of a reason, or it could be a visit in course or the due for the employment also. That will be a part and parcel of the workplace. So let me give you an overall recap of the three basic definitions of the Vishakha Guidelines. The first is the aggrieved woman. The aggrieved woman is one who is either on a regular employment or a temporary employment or the ad hoc or a daily wager. But in that case, definitely the working for remuneration, it could be voluntary also. It is not that a woman is working for only money. She could also join an organization voluntarily, because to show her potentialities and capabilities, it is not mandatory for her to have always the salary. It could be a voluntary type of a work also. So it could be a trainee, it could be apprentice, it could be a visitor, and even the women who are working in the dwelling places or the house will also be called as aggrieved women. Now, coming on to the extensive definition of the workplace could be a public company or a private company or a hospital, sports dwelling houses, the office parties, the outsource, the outbound trials, the client meetings, or going out trainings for any kind of a reason which is related to your official work. If the woman is going out for any reason, if she's in a regular employment or a part-time employment or a daily wager, I have already issued the guidelines relating to it and discussed that also. So that particular thing will be called as a working place. So we have done till now the two basics of this guidelines. The first was the aggrieved woman, and the second was the workplace. Now, coming on to the major and the central issue for which these guidelines are formed, they are called as the sexual harassment. Now, what is a sexual harassment? It is bullying or coercion of a sexual nature, or the unwelcome or inappropriate promise of rewards in exchange for sexual favors. In most modern legal contexts, sexual harassment is illegal. The sexual harassment is gross violation of women's rights to equality and dignity. So if this particular type of an act or this kind of a favor is asked from a woman, that we will be giving you the rewards, or we will be giving you certain kind of promotions, but in exchange you have to give the sexual services, or the sexual favors in this case, so that is completely illegal, and because it is against the women's rights of her life and definitely against the equality and the dignity of the women. So these kind of acts are called as the sexual acts, and this sexual harassment is given under section 2 subsection N of the Act. So you can have a look on the Act and the guidelines in detail for your reference and for your implementation in policy, because we are here giving you an overview of what these concepts are all about, so that you have a prior information about if these kind of incidents happen at the workplace, what are the redressals, what are the guidelines which are given in the Act, so that you can immediately implement that Act, because this is a very criminal offense and should be immediately controlled, and it's a kind of an emergency which should be looked upon immediately. Now coming on to the sexual harassment definition, which is given under the section 2 subsection N of the Act. The sexual harassment includes what? The sexual harassment includes any one or more of the following unwelcome act or the behavior, whether directly or by the implementation, namely the physical contact and advances, a demand or a request for sexual favor, sexually colored remarks, showing pornography or offensive or derogatory pictures, cartoons, etc., any other unwelcome physical, verbal or non-verbal conduct of sexual nature. So we have seen here that the kind of sexual harassment definition is quite extensive in nature. If any kind of derogatory remarks are given to the women, or the act of pornography is shown to her in the form of the pictures or in form of the cartoons, or any unnecessary comment which is an unwelcome comment is given to the women, and of course any kind of a sexually colored remark is always unwelcome in the workplaces, and of course the physical advances and the contact is definitely a part and the parcel of the sexual definition of sexual harassment, section 2 subsection N of the Act, which always carry a very serious repercussions as far as the legalities are concerned, because these are offenses and a criminal offense which is considered, that is the sexual harassment at the workplace. So everyone should be aware of these kind of acts, because these are so severe and grave, and it is directly attacking the dignity and the respect of the women, which is definitely the 50% of the population, and she should be given a kind of a respect, and that is why she is considered to be a subdued sex. So all these the legal redressals are offered to her because of the cultural flaws and certain other shortfalls, because of the Indian society, because of her stereotype role. It is very important to empower the women. So to give her the empowerment, that is why each and every severe detailed incidents are mentioned in the Act, because if she is a victim of any kind of act, immediately the redressal could be given to the women. Now coming on to section 3 subsection 2 of the Act. The following acts, when in relation to behavior of sexual harassment, may be amount to sexual harassment, that is implied or explicit promise or preferential treatment in her employment, implied or explicit threat of detrimental treatment in her employment, implied or implicit threat about her present or future unemployment status, interference with her work, or creating an intimidation or offensive or hostile work environment for her, humiliating treatment likely to affect her health and safety. So we have seen here that all these particular 5 types of acts which are explained in this definition, they are all against her dignity and respect. Like for example, the persons who are in a superior position and are able to give the promotions, etc., if they tell a woman that we would be giving you a shortcut for the promotions if you do some sexual favors for us, then of course it is a real serious offense and it must be remoted immediately, followed by that if you do not give us the sexual offers, then we would be not taking care of your promotions, and you can see your future that you can be even unemployed, specifically in case of private companies. And of course if any case of intimidation or offensive hostile environment is given to her because of her it is affecting her health and safety issues, etc., again she will be terrified, she will be terrorized, and all these acts are tantamounting to sexual harassment at workplace, which is mentioned under the section 3 subsection 2 of the Act. Now what are the various forms of workplace sexual harassment needs a detailed considerations and discussion. So let me have a good look at it. Quid pro quo, this is for that, this for that. It implies explicit promise of preferential detrimental treatment in employment, implied or expressed threat about her present or future employment status, hostile environment, that is creating hostile, intimidation or offensive work environment, humiliating treatment which is going to likely affect her health and safety issues. So this is a quid pro quo. this is a kind of this for that, that if you give us the sexual offers, we will give you the employment. So they have, actually many of the organizations are into all this, specifically, not naming the centers, but there are certain call centers in which the sexual complaints are rising like anything, and giving the names would be not considered good. So overall the situation is going from bad to worse. So all these type of incidents in which there is a quid pro quo, that is this for that, should be immediately reported to the authorities, and because this is such a grave offence that if the redressals are not taken care of in the organizations, you have the other rights also, which we will be discussing later. So overall, the examples can give you a fair meaning of the sexual harassment at workplace. Let me give you certain examples. The first is the sexual advances. The second is the unsavory remarks, jokes causing or likely to cause awkwardness or embarrassment, injurious and taunts, gender-based insults or sexiest remarks, unwelcome sexual overtones in any manner, touching or brushing against any part of the body and like, forcible physical touch or molestation, physical confinement against one's will and any other act likely to violate one's privacy, then abuse of authority or the power. So these are the particular examples of the sexual harassment at workplace, and you must be aware of these facts, that these things are subject to punishment and subject to redressals. It is very important to spread the awareness of Vishakha Guidelines and the guidelines specifically to the girl students and the working women, because they should know their rights, who they are and how they can protect themselves in this modern contemporary world in which they are going out of their houses and working like males. So they have a right for their rights to be protected against any of this severe and very bad act which has been done, and they are being if they are a victim of these, what are the redressals available for the women in this regard. So in short, we can say that the workplace harassment is when the behavior is unwelcome, it is sexual in nature, it is a subjective experience, and it is the impact, not the intent, that matters. So we should be, as a woman, know yourself, protect yourself is the message which I want to give through this lecture. Now coming on to the workplace sexual harassment, typically involves the acts of which the victim has a reasonable apprehensions that they are humiliating, unsafe, unhealthy, discriminatory, career limiting, and otherwise causing the adverse circumstances. So definitely, if any of the act of this kind of an act, that is the humility, unhealthiness, unsafe, derogatory, discriminatory, career limiting, and otherwise a very bad comment is given to the women, of course, these are all under the bracket of reasonable apprehensions, and she has a complete right to say no to it, that she cannot accept and should not be accepting any of these kind of statements. Now, definitely sexual harassment is a very serious criminal offense which everyone should know. Now, there are certain provisions of the sexual harassment at workplace in the Indian Penal Code. Now, under section 354, which is the assault or the criminal force to women with the intent to outrage her modesty. Whosoever assaults or uses this criminal force to any women intending to outrage or knowing it to be likely that he will thereby outrage her modesty shall be punished with the imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. So definitely this particular section of section 354 of the IPC is very, very severe, which is definitely called as a criminal offense, which can also counter the imprisonment and a big fine, and as per the severity of the act, with both, that is the imprisonment and with the fine. Now the sexual harassment under this section 354A of the IPC, that is the Indian Penal Code, the physical contact or advances involving unwelcome and explicit sexual overturns are a demand for request for sexual favors, showing pornography against the will of a woman, making sexual colored remarks. So, if the case lies under section 354 subsection A, this particular act is even more severe, and it can also give you a criminal liability of 5 years of imprisonment and with a fine or with both. So, showing these kind of pornographic, showing this kind of sexual or asking for these kind of sexual favors or making some kind of sexual colored remarks can give you an imprisonment of 5 years, and it could be even extended for more as per the severity of the incidents. So, we have seen till now that if a woman is a victim of a sexual harassment at workplace, so there are certain protection which is given to you under section 354 of IPC, section 354A of IPC, which is very, very important to understand, and the spread of this among the males is also very important, that if they are indulging themselves into this shameful activities, what are the repercussions of all this? That they can be even, there is definitely will be a social stigma and taboo on them, followed by the imprisonment and followed by both. So, they can lose their the reputation in the society, because it is the women who will be heard in this case. Of course, definitely the case has to be truthful, because there are certain incidences of this kind that if you lift the veil and if you actually see certain incidents, they are also fraud cases also which are reported by the women. So, in both cases, male and female are both important pillars of the society. These acts are for the protection, not for settling the personal scores of you in that case. So, if the matter is important and it lies under the section 364 and 354 and 354A, it must be reported immediately, and under section under the Indian Penal Code, the redressal will be given to you in terms of imprisonment of the people and followed by the fine. Thank you so much. So, we are under this backdrop of saying that sexual harassment is a very serious criminal offence, and we are discussing now the redressal which are available to the women under the IPC, and we have discussed till now the section 354, which states that is the assault or the criminal force to women with intent to outrage her modesty can be subject to imprisonment of 2 years and with the fine or with both. And then we came on to the section 354 subsection A of the Act, which states that if there is a forceful physical contact with a woman, or there is a demand for any kind of a sexual favor, or there is a showing of a pornography and making sexual colored remarks, the consequences are so grave that this can even give the indulgence of any kind of a man who is doing this with the imprisonment of 5 years and with the fine or with both. Now, taking it forward, we have another section, section 294 of the Indian Penal Code, that is obscene acts and the songs. Now, this particular act is centering around these obscene acts and the songs. So, let me have a deep coverage of this. Whosoever, to the annoyance of the others, does any obscene act in any public place, sings, recites or utters any obscene song, ballad or words, or in nearby any public area, shall be punished with an imprisonment of either a description for a term which may extend to 3 months, or with fine or with both. So, this kind of obscene acts and the songs should be avoided at any cost, because this is also a very serious offence which can also give you an imprisonment of 3 months and with fine or with both. But in all and most of the cases and all of the provisions under the Indian Penal Code, you will be losing your dignity, you will be losing your respect, you will be losing your reputation as a male, that you are doing all these stupid acts, criminal acts against the women. Now, there is another section called 509, which states any word, gesture, act intended to insult the modesty of a woman is also very, very important, will have a very serious important repercussion for the males. Whosoever intending to insult the modesty of the women, it utters any kind of words, makes any kind of a sound or a gesture, or exhibits any object intending that such word or sound shall be heard, or that such gesture or object shall be seen by such women, or intrudes upon the privacy of such women, shall be punishable with a simple imprisonment for a term which may extend to 1 year, with fine or with both. So, this case also, the words, the gestures and the acts which the males are doing at the workplace, they should be very cautious about using the choice of the words, the gestures what they are doing, because it is in any case insulting the women, the modesty of the women. So, they should be very careful about using of all these gestures, words, the combination of all these, because they are resulting into the insult of a modesty of the women. So, this should be checked at any cost, because this is also liable for 1 year imprisonment with fine or with both. Now, we have another IPC provision, that is section 354 subsection B, that is section 354B of IPC code. This is assault or use of a criminal force to women with intent to disrobe her. Any male who assaults or uses the criminal force to any women or abets such act with the intention of disrobing or compelling her to be, out of clothes, shall be punished with an imprisonment of either description for a term shall not be less than 3 years, but which may extend to 7 years also, which is also can also be given for a liable for a fine also. So, this is a very, very severe, code which the Indian penal has given us. So, any ineligible act, any criminal force which is used against the women to remove her clothes is so severe that this can give her the overall punishment of imprisonment of 3 years, which can even extend to 7 years, and with the fine also. So, we have seen till now, there are certain recap of the provisions which I want to give you right now. The first was section 354, that is the assault or criminal force to women with the intent to outrage her modesty. The fine and the 1 year imprisonment is the case in this case. And the next is your section 354A, which states for any kind of a sexual harassment, favors or making certain sexually colored remarks, followed by showing pornography against the will of the women, can also give you an imprisonment of 5 years with fine or with both. Then we have section 294, that is the obscene acts and songs. So, this can also give you a punishment and imprisonment of a particular term which may extend to 3 months with the fine also. Then we have section 509, that is any word, gesture or a word which is intended to insult the modesty of a woman, can also be subject to imprisonment of 3 years and with the fine or with both. Then we are coming on to a very serious code, section 354B of the Indian Penal Code. This is something which is really bad, that is use of any kind of a force to remove her clothes can be subject to a punishment of not less than 3 years, which can even extend to 7 years or with both, with a fine also. Now coming on to another penal code, that is IPC 354C. Now this section of the 354C of the Indian Penal Code is voyeurism. Any male who watches, captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by a perpetrator or by any other person at the behest of the perpetrator, or disseminates such image, shall be punished or first conviction with imprisonment of either description for a term which may not be less than 1 year, but which may extend to 3 years also, and shall be liable to a fine also, and be punished on a second or a subsequent conviction with the imprisonment of either description for a term which may not be less than 3 years again, which may extend to 7 years also, and shall also be liable for a fine. The explanation for the purpose of this section, that is the private act, includes any act of watching carried out in a place in which the circumstances would reasonably be expected to provide privacy, and whether the victim's genital, posterior and the other portion, private parts of the women are covered only in the main basics, and the victim is using a lavatory, or a victim is doing a particular act ordinarily not done in the public. So whether the victim consents to capture such images of any act but not their dissemination at the third person of such image, or the act is disseminated, such dissemination shall be considered as an offence under this act. So as we are moving on to the provisions which are given under the Indian Penal Code, the severity, imprisonment and the fine, everything is increasing. Now this particular provision of section 354 subsection C of the Indian Penal Code Acts is very again important, which states that there are certain particular acts which the women are supposed to do in a very private situations, and a perpetrator or person who is trying to intervene in the privacy of the women and captures an image of that particular act in which she is engaging in a privacy, that is also considered very illegal, and there are severe repercussions that you can see that the severity can include even the imprisonment of even more than 7 years with the fine also, or with both. So a perpetrator or a person should not be doing all these, because everyone has a right to privacy. So the privacy should not be indulged or captured of the women in any case. Now coming on to another provision, that is the Indian Penal Code 354D of the Indian Penal Code, that is the stalking. Any man who follows a woman and contacts or attempts to contact such women to foster the personal interaction repeatedly despite a clear indication of disinterest by such women. He monitors the use by women of internet, email and any other form of electronic communication, commits the offence of stalking, provided such conduct shall not amount to stalking if a male who pursued it proves that it was pursued for the purpose of preventing or detecting crime, and the male accused of stalking had been entrusted with the responsibility of prevention and detection of crime by the state. It was pursued under this law, or to comply with any condition or requirement imposed by any other person under the law. Whosoever commits the offence of stalking shall be punishable on the first conviction with imprisonment of either description for a term which may extend to 3 years, and shall also be liable for a fine, and be punished on a second subsequent conviction with imprisonment of either description for a term which may extend to 5 years, and shall also be liable for fine. Now this kind of a stalking is a punishable offence under section 354D of Indian Penal Code. Now the stalker will take care of the women social website working websites like Facebook, LinkedIn, emails and other electronic media, where the male is constantly watching and constantly tracking the system in which she is doing such emails and contacts with the the public or the public profile of hers, what kind of pictures she is posting, and has the complete update of her latest doings, is called as stalking. And he commits a crime of stalking, which is definitely not good. It is a severe criminal offence under the IPC of section 354D. But yes, if that person is given a responsibility by a state for any reason, for any particular case, or for that matter the national security reasons, or she has been under the surveillance, so in that case the stalking is allowed, but that person has to prove that he was engaging himself into the act of stalking because of these reasons. So again, the stalking should not be done, and the crime is so severe that in the first conviction the punishment is for 3 years, which can extend to 7 years in the second conviction, followed by even the fine also, or with both. Now coming on to the civil remedy under the posh criminal remedy under the Indian Penal Code. Now section 2 of this act is for the prevention and prohibition of sexual harassment at workplace. Now who is responsible and accountable for prevention? There's a big question mark on this. What is the role of the workplace in prohibiting, and how? That is how the employer can play a very significant and contributing role to control the sexual harassment at workplace, and what is the role of the workplace in this case? They are the matters of serious concern and a matter of debate also in certain reasons, because there are certain employers who are least bothered about this most important complaints which can be coming through the female employees working in your organization. The employer shall create a workplace which is free of sexual harassment. Now, who is an employer? The workplace of a central government, state government, local authority, body, the head or the officers specifies. The second is the private workplace, the person responsible for the management, supervision and control. The third is the dwelling houses, that is the person who employs the benefits from the employment. So we have seen here that there is a specific certain role which the employer has to play. Now who is an employer? It contains a bigger definition of the workplace, that is the central, the state, the private and the dwelling houses. Now coming on to what are the vital duties of the employer. Every employer shall provide a safe working environment at the workplace, which shall include the safety from the persons coming into contact with the workplace, display at any conspicuous play in the workplace the penal consequences of sexual harassment, and the order constituting the internal committee or the internal complaint committee under this law. They should organize the workshops, awareness programs at a very regular intervals for sensitizing the employees with the provisions of Act and oriented programs for the members of the internal complaint committee in the manner as they may be described. They should provide necessary facilities to the internal committee or the local committee as the case may be for dealing with the complaints and conducting an inquiry. Assisting in securing the attendance of respondent and witness before the internal complaint committee or the local committee as the case may be. Now, there is a complete duty chart which has been given for the employer, because employer is the one in which they play a very significant role in safety issues and controlling the complaints of this kind and the sexual harassment at workplace in this kind. So number one is that whatever is the internal complaint committee which has been constituted in a legal way, and there's a procedure to form the internal complaint committee also by the employer, all the rules must be adhered to, and whatever is the committee which has been formed at the office level, whether it is a private, public or a central office, it must be displayed everywhere with the proper numbers, phone numbers of those people who are responsible for giving you the redressal as far as the internal complaint committee is concerned. And there should be other kind of boards also which shows the gender sensitization that we respect women, and at no cost the women will be disrespected, or any act of sexual harassment will be avoided at any cost. So this message must be given by the institutional employer to the society at large and to the people who are working in that organization at large, that this will not be taken at any cost, and if any of the matters which are of grave concern of this nature will be taken care of in a very serious manner, which has a serious criminal liability and the fine both. And in this regard, there is a prime responsibility of the employer to conduct the educative programs, the symposiums, the talks, the seminars in this regard also, because gender sensitization is very, very important and a very pertinent issue for the Indian society, and for that matter the global society at large. So we should take up, we means the employer, take up the responsibility of the gender sensitization, taking care of the safety and the health issues of the women, a top priority, by empowering the internal complaint committee with all the facilities which can give them good redressal. The victims and the aggrieved women can be given a complete redressal of whatever happens to them, that is the sexual harassment at the workplace. Now there are certain other duties also. Let us have a look on this. They should make available such information to the internal complaint committee or the local committee as the case may be, and it may require, having regard to the complaint made under this law, they should provide assistance to the women if she chooses to file a complaint in relation to the offence under the Indian Penal Code, that is 45 of 1860 or any other law of the time being in force. They should also cause to initiate the action under the internal complaint committee 45 of 1860 or any other law for the first time being in force against the perpetrator, or if he has aggrieved women so desires, whether the perpetrator is not an employee in the workplace or at the time of incidents of sexual harassment took place. That they should treat the sexual harassment as a misconduct under the service rules and initiate an action for this misconduct. They should monitor the timely submission of the reports of the internal committee. Now this also gives a lot of importance and lot of significant role to the employer, that if any untoward incidents against the women, that is the sexual harassment at workplace, comes to them in their notice, so they should give complete backdrop, complete facilities to the women to file a case against under the any Indian Penal Code as per the situation which has occurred at the workplace. Not only this, the employer should be completely in contact with the internal complaint committee of what is happening, and they should always keep themselves in the loop of the ICC, that is the internal complaint committee, of any such case which happens at your organization level. So if they monitor in time, the things will be under control and the redressal can be given to the aggrieved woman in time, and which is the prime responsibility of the employer in this case. Now the employer shall create and communicate a detailed policy. They should ensure the awareness and orientation on the issue. They should constitute the complaint committee. They should ensure that the complaints committee is trained in skill and capacity. They should prepare the annual report to be submitted to the director's office, and the report in the director's also has to be submitted. It is the employer's responsibility to prevent and deter committing of any such sexual harassment by means of creating of appropriate working conditions, ensuring the female employees are not treated as sex objects, ensuring that no male employee or third party will outrage or insult the modesty of a female colleague, ensuring that no male employee or third party will make any type of sexual advances to the female colleagues, and they should establish a complete complaint committee at the organizational level. So we call it as ICC or LCC, Legal Complaint Committee or Internal Complaint Committee. The members to hold the office for a term not exceeding 3 years, and in some cases it is 2 years. The Internal Complaint Committee for each branch office, if there are multiple functions, to educate, sensitize the employee about the issue, to address the complaint, conduct inquiry, etc. It operates as a quasi-judicial body with the powers to summon and enforce the attendance and call for the evidence and documents. So we have seen here that the Internal Complaint Committee, that is the ICC and the LCC, are so empowered, and they are also called as the quasi-judicial body which has the power to call upon any kind of issues, or they can also issue the summons, and they should also enforce the attendance of the convict also, and the complainant also, and they should also call for the any kind of evidences do they want and any kind of documents do they want. Now the Internal Complaint Committee, they should be constituted through a written order. 50% shall always be women is the complete mandate. The chairman has to be a working woman at a senior level as an employee. 2 members from against the employees committed to cause of the women having a legal knowledge, experience in the social work. The members, one of them should be from NGO, that is the non-government organization, associations committed to cause of the women or a person familiar with the issue of sexual harassment. It is the office are located at different places. Each place needs to have an ICC. For example, an office has 3 branches. So all the 3 branches must have a constitution of Internal Complaint Committee, because there cannot be one complaint committee for all the different branches. Each branch is mandatory to have its own ICC on a daily basis to control the crime against women, to ensure her safety, of security of her issues, so that nobody is able to even raise voice against any kind of these kind of issues, and they are even nipped in the bud in this case, because if there is a proper machinery which is functioning against all such issues against women, there is a kind of a moral pressure on the males also in this regard, that they will not dare do any kind of act, because if they do that they will be convicted, and which is definitely a criminal responsibility, criminal liability also for them. So overall, the chairman, again the 50% shall be women. It is constituted by the district officer. The eminent women in the field of social work committed to the cause of women has to be a chairman. That is the local complaint committee I am talking about. 2 members from the employee constituted to cause the women having a legal knowledge, experience in social work, and ex officio members are the concerned dealing officers with social welfare of women and child development in that district. So they become the ex officio members. So we have talked about the Internal Complaint Committee, which is internal, and we also have a local complaint committee which also takes care of the women issues and other issues. The ex officio members are the persons who are dealing with all these issues, and definitely who are involved in these social welfare activities. The complaint committee should be thoroughly prepared with a written order. They should know the act, they should know the policy, they should know the relevant service rules. They should gather and record all the relevant information deeply. They should determine the main issues in the complaint, that what are the issues which are centered around, what are the pertinent issues which the women is complaining about, so that we can immediately put that complaint under a particular section of the Indian Penal Code, whether it is section 354, 354A, B, C, etc. or D. You have to analyze the information gathered by the women. They should prepare a report with the findings and followed by the recommendations also. They should maintain the confidentialities, because it is very serious and a pertinent issue and a very grave issue, and owing to which they have a legal liability, imprisonment and the fine. So the confidentiality has to be maintained very, very importantly. Followed by the decision which the internal complaint committee will take, it has to be impartial, because there is a body above this also who can also take care of whether the working of the internal complaint committee is not biased at all. And there are no personal scores which are settled in this case. So it has to be impartial, it has to be non-retaliation, and it has to be clinically proved also. So there should not be any kind of the repercussion which is not supported by the legal evidences. So they should be clinically proved if there is a rape, if there is an any kind of sexual harassment case at the workplace, and they should have a complete record, recommendations, reporting, and nothing of the other things must be left at the part of the organization. So overall, let me give you a recap, because in the following coming lecture also we will have a lot of discussion about this, because it's a very detailed act. So we have the most important part of the lecture today was the sexual harassment is a very serious and a criminal offence. Let me give you the tips of the the lectures today. The first provision under the Indian Penal Code was section 354. This was against the assault at the outrage intent for her modesty, respect and dignity, which gives you the penalty of the fine followed by the imprisonment of 1 year. Then we have section 354A of the Indian Penal Code, which gives you an imprisonment of 5 years and with both, because here the sexual harassment is done in the form of asking for the sexual favors, followed by showing the pornography against the wishes of the women, and of course making the sexually colored remarks. Then we have section 294, that is the obscene songs, etc. The serious repercussion is that this is most importantly happening in case of colleges, in case of the institutes, educational institutes, etc. So we take care of no ragging form right on the first day, that this is a very serious and a legal offence if you are involved into any kind of obscene acts and the songs, so they should be avoided at all cases. Then we have section 509, which states that the word gestures must be very diligently used by the males, because this can also give them the imprisonment for a term of 1 year with a fine or with both. Then we have section 354B, which states that if there is an assault or a use of a criminal force to the women against the intent to disrobe, that is any kind of force which is used against her to remove her clothes. This is a very serious offence, and the imprisonment could also be up to 7 years with a fine or with both. Then we have 354C of this act, which is definitely the stalking, the voyeurism, and all these cases must be avoided. Then we came on to the remedies, in which we talked about the prevention and prohibition, and then we talked about the how the internal complaint committee and the local complaint committee is formed, with the equal representation of the social working, with the advocates, with the senior female working at your levels. And then we talked about the duties of the employer, that he must create the environment of women's safety and other pertinent issues relating to women, and the gender sensitization policy must be advertised by the employer every now and then, followed by conducting of certain seminars, talks, so that the message is disseminated to the males that they should not be daring to do any kind of a derogatory act, any kind of a criminal act against the women. How the internal complaint committee and the local complaint committee is formed, we discussed on that. So I hope the women is enlightened. In the coming lectures also we will be talking about the same issues in detail. Thank you so much.
With this note, thank you, ma'am. Thank you so very much for raising certain burning issues over here, and we believe that all the working places would be appropriate and very good for all the women and the men working in the organization. And dear friends, we believe that your feedbacks are important for us. Do write to us at info.cc@nic.in. We would be meeting soon. Till then, take care. Goodbye. Thank you, ma'am. Thank you once again.